going to be
a brief introduction, please. So, and I would also like you to do same as well too. Yeah. My name is Dr. Simon Ayolo St. Emmanuel. I'm a senior lecturer at Adekunle Ajasin University, Akumba Koko. Yeah, we are also double as the acting head of the Department of Jurisprudence and International Law. So I'll be sharing this panel, and we have Professor Sam Erugo, Senior Advocate of Nigeria from Abia State University, Dr. Titilola Hameed. Am I right?
Correct.
Yeah, okay. From Nigerian Law School, and Mrs. Omoyemen Lucia Odigie-Emmanuel from Nigerian Law School and Yenagoa campus. So
do I introduce myself first?
Okay, please go ahead. I was thinking the Learned Six should introduce himself, maybe for purpose of seniority, but I don't think he's online anymore.
Okay. Prof actually sent a message that I may not be able to present today, so I'm actually not sure that he will come online. Did you see him online before?
I think I saw him briefly when I walked back into the room to talk with the technical guys. I noticed he was trying to connect earlier.
He'll probably join us if he can. Okay, good day, colleagues. My name is Omoyemen Lucia Odigie-Emmanuel. I'm a lecturer with the Nigerian Law School and coordinator of the Nigerian Law School Yenagoa Law Clinic. Thank you.
You're welcome.
Do I go next?
Yeah, yes, ma'am. Please
I'm
do.
the only one anyway. Right. Good evening. I'm Dr. Titilola Hameed. I teach at the Nigerian Law School Lagos campus. I head the Department of Professional Ethics and Skills, Lagos campus. It's nice to be here.
Okay, thank you, ma. You're welcome, ma.
Okay.
Okay. Let's do this where we have him 1 hour 30 minutes, and we've spent 4 minutes out of it already. I think Mrs. Omoyemen Lucia.
Yes, I've sent you my presentation. Can you please confirm that you have it, because you are supposed to share it?
What I want you to do, yeah, you can share it on the screen. Yeah, I think the Learned Sick is back online.
Yeah, it's back. It appears it's back. Yes.
Okay, let me add him as a co-host. Learned Silk, you're welcome.
Thank you, my brother. How are you? I'm
fine. Good to see you again, sir.
Yeah, good to know you can hear me.
Last time I saw you was at the on the Law Teachers Conference at Abia in 2015.
Yeah, that is true. Yes, good to know you made it to that place.
Yes, yes, sir. Thank you, sir. Yes, sir.
Yeah.
Okay, sir. Thanks for joining us, sir.
Yeah.
Yeah. Other Mrs.
I sent my. Yeah, Emmanuel.
Yeah, well, I'm listening, sir.
Yes, I sent my slide this morning. Did you get them?
Okay, sir. But you can still share it with us here, sir. That's why you're a co-host.
I hope I can, because I'm catching a flight in the next 30 minutes. I'm at the airport. But I will try what I can.
Okay. Maybe you should go first then, sir. Since so we'll be having 20 minutes each.
Okay.
Yes, sir. No, okay. Let's make it 15 minutes each. Let's make it 15 minutes each. Then the rest of the session will be spent on questions and answers.
Please, can I just interrupt briefly? While Prof is sharing, can you please prepare to share my own slide? I don't have it with me here. I'm using.
No, that's why you're a co-host. You're a co-host, so you can share it now. Mrs. Odigie-Emmanuel, you are a co-host. You can share your slide.
I'm not using a device that can do that, because yesterday I could not. So I'm not signed on in my laptop. I need your assistance.
Actually, it's my phone that I have here. I'm making use of the laptop provided by the organizer.
Okay. I had difficulty joining Zoom on my laptop, so I'm using my iPad.
And you can still share your slide.
Not on my iPad.
I don't have it here. You sent it to me this morning, but I think it's on my phone because I don't have my laptop here as well.
Can you send your email? Okay, you also do not have your laptop there.
Yeah, I don't have my laptop. I'm making use of the laptop being given to us by the organizers. So please, in order not to run out of time, let's Prof begin his presentation, present his paper.
Thank you, my brother.
Yeah, you're welcome, sir.
Good morning, dear everyone.
Good morning, sir.
Good morning.
Good morning, Prof.
Can you hear me? Yeah.
Yes, we can. Yes, we can hear you, Prof.
Okay, my presentation is very simple. I started by looking at the centrality of ethics of our profession, which we all know that legal ethics is just there, sacrosanct at all times, even in the times of crisis. We all know that. And in many discussions, it has been emphasized that the lawyer, once you become a lawyer, you have to live with ethics until you are gone. And I moved on to look at the usual dilemma of the lawyer as between his duties to the profession, particularly duty to do justice whenever it occurs, his duty as an officer of the courts, and his duty of privilege and confidentiality with his clients, comparing that with his duty of devotion, the one we call the zealous advocacy of the lawyers. I also looked at the duty of candor, comparing with the fact that the lawyer could exert all his energy and expertise in the defense of his clients, and so many other duties, which every day appears to conflict with each other. Those are the bases upon which I looked at the topic, contextual perspective to crisis-driven ethical dilemma of the lawyer in Nigeria. By that, I mean that we should isolate the two perspectives. There's a global perspective of crisis, which appears to be global. COVID-19 appears to be the most serious, the calamitous, which has refused to go. We have economic crisis everywhere. We also have wars everywhere. That is one perspective. There's a second perspective of what I call Nigerian or African localized crisis, which includes corruption, failure of governance or states, and insecurity. There are so many we can mention here, but I'm using those ones as examples. Those are dimensions of crisis that appear to haunt the lawyer every day in Nigeria. So contextual localized factors in the crisis generally could include failure of governance, unbridled corruption. When you talk about failure of governance or state, we are talking about failure of rule of law, particularly crime and punishment. Then we talk about failure of ethics or value in governance, which leads to official impunity. To me, these are the most crucial of the crisis in Nigeria. Then we are also looking at incompetent judges. Judges are appointed in the work of impunity, official impunity, and corruption in Nigeria. We're also talking about poor human rights regime and the failure of regulation, including regulation by the bar and the NJC. Then we also talk about hunger and ignorance in Nigeria. These are all pervasive. So my question then is, in view of these dimensions of crisis and the contextual perspectives I've painted, how is the lawyer affected in his ethics, in his everyday work as a lawyer, in lawyering? And position is that the immediate implication is the increasing lawyers' ethical dilemma in Nigeria. Pinpointing to the issue of COVID-19 pandemic or lockdown period, we found out that these were epitomized in the peak of these factors. For instance, the injudicious and ill-conceived COVID-19 measures by the government, including emergency regulations, restrictions, petty crimes, summary trials, deprivation of human rights, bad governance, compromised and incompetent judges, and so many, coupled with hunger and ignorance in the land, led to a crisis of rule of law. Question is whether that could be rule of law or rule by law. So many of us in Nigeria will know that during that COVID period, even though there were restrictions, government officials were moving about. But the average Nigerian moving along the road will have to deal with security agents on the road. And of course, if you could bribe your way, you have your way. You can get to anywhere in Nigeria once you're able to bribe the police checkpoints. Even in those cases where the magistrates were mounted for trial of petty crimes, you find out that provided you can pay, you get to wherever you are going. So my position is that in all these situations in Nigeria, the more regulation, the more petty crimes you create, the more vulnerable the lawyer will be. Because take, for instance, in those cases of emergency, where your client is detained, and you find out there is nothing you can do except to give the tip, probably will say it's a case of doing public relations to get your client out. But your client has to come out. If you don't do it, your client will want to do it himself. So you find out that the lawyer's dilemma is increased by the circumstances we find ourselves as mentioned in the paper. So there is increased temptation, even when you think you are strong. If your relation is involved, of course, you won't let him sleep there because you can't do PR. And of course, when we talk about lawyer not taking the brief in the client's house or in his office, how many people could afford to do that during the COVID period? How many people could afford to insist on those rules in the face of hunger, biting everywhere? Bribing of officials of government at every level was rampant. Even to file or retrieve documents, you must do PR. We call them PR because we want to shift the blame. Probably there are no longer ethical issues. So in those cases of emergency, you find out that the lawyer's position is to a large extent in jeopardy. So I know there are wider ethics in the face of incompetence and corruption that you face in those cases where unless you see the judge, even if you don't bribe, unless you see him, you will not get justice in Nigeria. So my position is that the lawyer is exposed more to ethical dilemma by these localized extreme circumstances. Thank you. I'll be expecting reactions to this. And I had thought we will have participants from all other jurisdictions who could contribute. I know that in a case like UK, regulation is more rigorous. In so many advanced democracies, the rule of law, the states will be working very well. I see that this pressure is not much on the lawyer. Probably a lawyer will do some of these ethical things because he wants to do and not because the situation, the circumstances of his state warrants him to commit those unprofessional conducts. So what do you think? Thank you, moderator. Are we here?
Yeah. Oh, thank you very much, Learned Sake, for the wonderful
I hope you
presentation.
heard me well.
Yes.
Yes, you were quite audible.
Thank you very much, Learned Sake, for the wonderful presentation. Okay. You said you want to catch a flight very soon, sir?
Yes, in fact, I think. Sorry for the noise.
Okay, no problem. Let me ask if because the whole idea is to take the questions answers after everyone has presented. But since you want to catch a flight, let me throw the floor open if anyone has questions.
Right.
You could answer before you take your leave, sir.
Yep. Please go ahead.
Okay. Any question on Professor Erugo SAN's presentation?
Yeah, I have my hand up, but I don't.
Oh, sorry. Sorry, you have the floor, ma.
Square.
You have the floor, ma.
Thank you very much for the presentation. Brilliant one. But my question now is, with all these vices, that are affecting us, that have eaten deep into the core of our existence, because these things are not going to go away anytime soon. They're going to live for another 50, 100 years. I'm sorry that I'm not optimistic. So in the light of the fact that these things are not going to go away soon, where would the solution lie? Which direction should we be looking? Thank you.
Prof, do you want to respond to that?
Well, I think she agreed with my position. So I think I presented so that we could excite more discussion on this, because more regulation by MBA, it appears, will not solve the problem. We are all witnesses to one or two incidents in the last few weeks and months in Nigeria, attempted by MBA to regulate itself appears to be dividing the bar. Some of the judges, like the chief judge of the Akwa Ibom State, it appears that nobody is talking about the mischief she's committing as we speak. So you find out that this corruption and incompetence appears to be endemic. And like she rightly pointed out, some of us are over 50 now. We are not expecting any serious change during our lifetime. So what do we do? That's the question.
Well.
Thank you. You're welcome, sir. Yeah, Mrs. Odigie-Emmanuel, please go ahead.
Well, I think that for us to be able to get any form of behavioral change, we need to use the tool of education. That's why we have in existence several initiatives, especially within the university community, from law schools, law clinics, where people are involved in education. For instance, in the Nigerian Law School Yenagoa campus, we have a program on education for justice and a culture of lawfulness. So by the time you begin to teach people about the need to live a life that is lawful, and they understand the implication of crimes in the real sense, they want to change. For instance, as part of that initiative, apart from teaching in schools, secondary schools, we also talk to communities and we talk to inmates. And I remember in one of our prison outreach, one of the inmates asked us specifically, he said, now that we have changed, we have changed our attitude. We didn't know it was like this before we got to this stage. Why are we not forgiving? We needed to help them understand the implication of crime, that, once you commit a crime, there is a legal implication. And once it gets to that stage, there's a sentence has been given. It's not like you are with your mommy at home and she says, kneel down as punishment. And then when she sees some remorse, she asks you to stand up. It's not like that. There are legal implications of crime that people do not really understand, especially young ones growing. So it's our responsibility to continue to educate them. Even if we cannot bend the very old ones, at least we can shape the young ones coming up. That's my take on that. Thank you.
Thank you very much, Mrs. Odigie-Emmanuel. Okay, Dr. Hameed.
Yes, I'm listening to what Dr. I hope we're watching time. I hope we have it. This is
Yes,
time.
we are running off soon.
Yeah, so listening to what Mrs. Odigie-Emmanuel has said, yeah, she makes a lot of sense. But I'm still skeptical in the sense that the people that are going to be the change drivers, who are they themselves? The prison warden, the police, the teacher, everybody has something, you know, that the person has not done right, or is not doing right, or will not do right. Okay, so these people that we are going to put this change in their hands, what kind of persons are they themselves? You know, so for me, I think it goes I can't lay my hand on what will solve it, but I still think it goes beyond asking people to make a change, because the people that are going to make that change, what kind of persons are they themselves? Thank you.
You know, the truth is that, can I just come in? If I could quote from the Bible, it said, be transformed by the renewing of your mind. I totally believe in transformational change that starts from changing the person's mindset. And I believe that the only way to do that is not just regulation and sanctions, but education, changing people's perspective. Let them understand why this has to be. When they change fully because it's based on conviction. But when it is not based on conviction, you will, and if people are just afraid of being caught, then when they come in contact with a sort of crossroad of choosing between hunger and punishment, which is not so imminent, they want to choose the way out because the punishment, they are not sure they'll be caught. But if they can, their mindset can change, we will have a better society. There's nobody who is above education. You know, my students have gone in the law clinic, have gone to the police station to teach them about torture and human and degrading treatment. The first time they received us, but by the time we went away, they put some kind of rudiments because the administration has changed. They wanted us to go through a very, very long bureaucratic process to be able to assess them, but we can't give up. We must continue using the tool of education to try and create change.
Well, if I have to say something, Mrs. Emmanuel, I like your optimism. And you know, I've been in this training from 2004.
I know your face very well, Prof.
From 2004, I've been training clinicians. We are pioneers in Nigeria. I agree with you. Yes, some of them we train turn out good, but I tell you, less than 5% of those who've trained all these years agreed to live this life we theorize about. So we're moving from theory now to practical. What percentage of your students trained in ethics live that life in society today? By the time hunger has beaten them, unemployment, and when they see that that is the way everybody in Nigeria, from the highest man down to the top, that is how they do it. You are forced to do it. That's exactly why we appear to be a pessimist in this case, because I've trained so many of them. I can identify 1, 2, 3 of them over these years who take up to these ethics of the profession. But what we are saying is that majority of Nigerians, in fact, it looks like Bioga Prosenes Ojukwu will say, it looks like the thing is in our blood. It's in our blood. Probably I'm in a public place, I won't mention it, but you can count from up. Just like Madam supporting me, I don't even know her name very well, sorry. But I mean, just like who is in control that will lead the pack? That's the issue.
It's Dr.
In a
Hameed.
society, yeah, thank you, Madam. Sorry. Your name is showing T square. That is why I'm confused. I was wondering whether it's the P square we have in Nigeria.
P square.
No, it's T-square, T.
T-square, okay, that's on a lighter mode. So what we are saying is, in a situation where you see from the highest person down, even those ones, these young ones look up to, you see them coming down to the lowest level in unprofessional misconduct. It's just difficult to understand. We are sounding this this way because we've looked around. It's difficult. It's in our blood. It's just something in us. In fact, even when you walk on the road and see the way people behave on the road, you know that we have a very long way to go. So we appreciate that, yes, training, yes, we are all in the training business, but how many of them will turn out good? That's my question. It's a difficult one. Probably will join you. You know, the average Nigeria, when things get out of hand, we'll go into prayers. But as for the current crop of Nigerians, it's really difficult. Check around you. Check among these students you've been training. How many of them accept this ethics? Some of them will ask you again whether that is what we eat. Thank you. Thank you. Permit me to, to keep quiet as I board my flight. I've enjoyed the discussion. That's exactly what we wanted to achieve, to excite this discussion. Probably we'll start doing it elsewhere after this this discussion.
Okay. Thank you very much, bro. Yeah, have a safe flight. Okay.
Thank you, my brother.
Yeah, you're welcome, sir. Okay. My co-presenters will be spending 15 minutes each, so could be able to meet up with the 12 noon. And then, so Mrs. Odigie-Emmanuel.
Okay, good day,
Yeah,
colleagues.
Yeah.
Okay, good day, colleagues. I've already been introduced. You can call me Lucia. I want us to start with a 3-minute snap discussion. Turn to your sitting partner, say hi, no introductions.
You have 15 minutes.
Yes,
Yeah,
we'll have a 2-minute snap discussion. Turn to your sitting partner, tell your partner one major way the COVID-19 pandemic affected legal education and legal profession in your country. Then also tell them the implication, the impact of that impact on professional ethics in your country. We'll just give you 2 minutes to do this. The chair will take some responses randomly at the end of the presentation. I hope there's somebody actually discussing this.
We just have 2 people. Just go ahead with your presentation. Just go ahead.
Okay.
Yeah, just go ahead with your presentation.
There is no, okay, I'm on into the presentation.
All the participants here are Nigerian.
There's an accord. So I'm into the presentation, thank you. So there's an accord in research from the North and South that law plays a key role in the development of any country. Legal ethics acts as an important guide to ensure rights and proper conduct in the daily practice of the law. Citizens' perception of how lawyers should behave makes it imperative to put the assessment of the effect of the pandemic on the professional ethics on the agenda for future development and reform. I agree with the author Nicholson that the question of how lawyers behave and hence the ethical values and principles which govern their behavior should be a central concern of legal education, especially ethics education. It's it's now very repeated severally that the COVID-19 pandemic opened to the world the effect of a global pandemic on legal education and the practice of law. You can hear me, right?
Yes.
Yes, we can hear you. Yes, we can.
Yes, okay. Since the inception of the pandemic, several authors have written on the impact of the pandemic on legal education, but however, there is need to examine the pandemic's impact on professional ethics precisely, both in the teaching of law and in the practice of law. So what we have done is try to examine the impact of the pandemic on professional ethics in the teaching and in the practice. As a background, the teaching of professional ethics at the Nigerian Law School is by use of exercises, group discussions, role-play debates, case studies, and students' presentation. This is usually done in the course of the lecture, and professional ethics is a main course taught once in a week. Professional ethics is also integrated into all other courses, and it's also taught as part of the induction course at the law clinic. The impact of the pandemic on legal education. The shutdowns of law schools and law clinic has interrupted existing model of in-person teacher-student training and mentorship. There are no physical lectures, no extension program could proceed. At the time of the pandemic, our students were just on the verge of leaving for extension, but none of them could actually report to the places to where they were posted. No physical interaction with beneficiaries of their law clinics, no direct, and then you have the direct and indirect impact of the pandemic on the health of students, on the health of lawyers, on the health of even loved ones who provide the financial support of for their training. In fact, a lot of students in their responses to a questionnaire mentioned this fact. Financial challenge posed by loss of income of sponsors affected their ability to even have access to data for participation in online classes when it proceeded at the Nigerian Law School. Difficulty of running large online classes was very, very evident in most of the institutions. For instance, in Nigeria, just the Nigerian Law School and some private universities were able to proceed with lecture and training in the course of the pandemic. They shut down all other aspects of the educational system. Even with the use of online classes, we had difficulty of running large classes in online class, as in using the online platforms. For instance, in my campus, we're taking about 400 and something students. Some campuses have more than 1,000 students. So to get all the students in the 6 campuses to be in an online platform was a very, very difficult thing. Then you also have the challenge posed by computer literacy and use of new applications. Several new applications for online training were launched at this time. And then you have the unsettled model of assessment of students using online classes. Within the legal system, there were some adjustments, virtual classes using Google Class and Meet for meetings, increased online interaction, use of video and lectures. Please, anybody not presenting, can you mute? Because I'm having interferences. We also had shorter lecture periods because of the online classes, and the suspension of group work, role play, and other effective methods of training because they could not be accommodated by the online classes, really. Just after the pandemic, I undertook a study, which was part of my presentation for the 2019 online GAGE conference, GAGE/IJCL conference. And one of the questions asked was, did online training during the pandemic positively or negatively affect your learning experience and understanding? 23.8% of students said it positively influenced their training, while 47.6% of students said it was a negative, impact it had on them. About 28.6% said it had no real impact on them. So on the other hand, looking at the legal profession itself, what was the impact of the pandemic? Negative impact on the health of lawyers. Several lawyers were ill, even clients went ill. Courts were locked down for months, resulting delay in the administration of justice. Increase in several deaths also meant increased property law transaction. Client interview, which is a key aspect of the legal practice, was suspended because only a few clients could be communicated with using online interview methods. Difficulty of electronic signatures was also key. So some pandemic adjusted trends in legal profession was we had at some points, there were virtual court hearings for superior courts, increased online interaction with clients, virtual mediation, there were even virtual sharing of documents. But this served a very, very small percentage of clients, because all clients in the rural areas actually were sort of cut off from access to justice. Now, looking at professional ethics itself, professional ethics is regulated by legal codes. Principle 26 of the UN Basic Principle on the Role of Lawyers states that codes of professional conduct for lawyers shall be established by the legal profession through its appropriate organs or by legislation in accordance with national law and custom and recognized international standards and norms. So in several jurisdictions, you have legal ethics codified, which form the basis of assessment of ethical conducts in the legal profession. In the course of this research, I looked at the rules of professional conduct in Czech Republic, Cyprus Bar Association Code of Conduct Regulation, Republic of Armenia Chamber of Advocates Code of Conduct, and Attorney Ethics Code of Albania, the rules of professional conduct for legal practitioners in the legal profession in Nigeria, and some of the scope of duties of lawyers looked at in the course of my research included duty to accept instruction, termination of representation, confidentiality, and I also tried to look at the integration of ICT in the rules themselves, the rules of professional conduct or ethical codes themselves. Now, in terms of summary of duties, in acceptance of brief, a lawyer is expected to take instruction from his client in his office in a place like Nigeria, except in special circumstances, which the COVID pandemic did not fall into any of those circumstances. The lawyer was also, when you take a brief, you are obliged to honor the commitments you have accepted, and in some jurisdictions like Armenia, Bulgaria, Flemish back codes of ethics, you have to verify the identity of a client before acceptance of the brief. All of this became very, very difficult, frustrated, because of health consideration of lawyers do not fall within rules of professional conduct. A lot of new dimension. Duty to verify the identity of your client was not possible. And then you had the issue of acceptance of brief. There were new strengths of brief also, because a lot of people wanted to file cases because they did not want to participate in the vaccination. So we had another strength of new kinds of brief that lawyers had to face an ethical dilemma whether to accept or not. In the case of confidentiality, confidentiality is a core duty of the legal practitioner. In communication between you and your clients, you are not supposed to reveal the confidence of your client. And if you have other people who have to contribute to the work your client's work, you have to ensure that they know about this duty of confidentiality and they are going to, keep to it. For instance, I remember I had to do a case in my years ago, which was brought under the Alien Tort Claim Act in the US. And the lawyers who were coming to Nigeria to do the disposition, my office was co-counsel. For us to be part of that, we had to sign documents, co-counsel, attorney privilege, contracts. So, but in the course of all these, the pandemic, this was a very, very difficult thing to do, because there was introduction of mandatory middlemen in many government offices that even when the lockdown relaxed a bit, the rules did not take into perspective a lot of things to do with confidentiality in an electronic format and dealings in most of the countries. So that was a problem. And then the pandemic affected so much the health of lawyers that the issue of competence became a very, very sliding issue. And competence is a key duty of a lawyer. Article 5, of the Armenia Chamber of Codes of Conduct, at the Attorney Ethics Code of Albania, Rules 14 of ROPC.
You have 4 minutes left.
4 minutes left. That is really, really difficult. Okay, so let's look at.
You have 4 minutes left.
Integration, yes. Okay, so integration, in most of the rules I looked at, I noticed that only the rules, Republic of Armenia, had a mention of electronic, and it was just in respect of filing. Most of the rules did not have an issue of how to integrate ICT in the practice of law. Now, one of my key recommendation, before I go into it, there was a particular rule of professional conduct that was quite inspiring, and that was that of Austral, Act Regulating Lawyers' Profession in Austral. It dealt with electronic lawyer signature, electronic legal communication, electronic register for lawyers' signature. And this is very, very key. So transition in times of pandemic was easier for them. So my key recommendation is that there's need for development of law policy on integration of policy on health and safety within legal education policies. There is need to mainstream health issues into trainings, not only in the classroom, but also in the law clinic. There's need to classify beneficiaries to be able to know which of them falls into a particular level of training needs. So another thing is that there's need to identify applications that can accommodate large classes and permit user-friendly breakout sessions to continue to use those online systems and prepare for future pandemics. It is important to do institutionalization of hybrid classes. We don't need to do away. It's one of the new norms that is to develop suitable model for online assessment. Then in terms of the legal profession itself, there's need to review the rules of professional ethics. A pandemic has shown us how much the transition can be frustrated because we do not have rules of professional ethics that are prepared for such transition. So it is necessary for professional ethics codes to be reviewed to integrate use of e-signatures and the rest. And some other innovations, some of the good parts of the pandemic coming in was that land documentation in a lot of registries, there was a good transition. For instance, okay, my 1 minute, I don't know what else to add. Okay, in summary.
Yeah, thank you.
No, I'm just going to put a key recommendation in conclusion so that I can use my 1 minute less. At least I'm entitled to that. It's important to know that the challenge is posed to the legal education and legal services by the COVID-19 pandemic calls for systemic review of all the recommendations, cataloging, and integration to make legal education and legal profession pandemic proof. Thank you.
Thank you very much, Mrs. Lucia Odigie-Emmanuel, for the wonderful presentation. Yeah, I appreciate it. So, Dr. Titilola Hameed.
Yes, I'm going to share my screen.
Okay, you have the floor, ma'am.
Can you hear me? Hello, can you hear me?
Yes,
we can hear you. We can hear you.
I know you have said 15 minutes, but you told us 20 minutes, so my preparation was for 20 minutes, but I'll try to keep within 15 minutes.
Okay.
Right.
Because we have less than 45 minutes to round off the session.
All right, no problem. You're welcome, everyone. And I have introduced myself earlier. The topic I'm looking at today is pre and post COVID-19, the reality for the Callow Advocate Court in between. So Callow Advocate is what we refer to in Nigeria as the new wig. Right, so my colleague has talked extensively about COVID-19 and the challenges that it brought along with it. So we know that its emergence was catastrophic. It virtually brought the world to a standstill. It altered the norm and created a new world order, and the aftermath of it lingers on, because in the conference, I noticed people are still wearing the nose masks. So there are different aspects of living that COVID-19 affected, and some of these are relationships. So you had people going into isolation or bonding on the other side of it. You had activities that disrupted routines. or you had people picking up new hobbies. You had the disruption of health of people, or attacks on health of people. So you had people dying or falling ill, or even falling into depression. Then you had challenges with work. So people lost their jobs, or their hours were cut short, and obviously that was less pay for them. It affected finances, and it affected education, which is what I am concerned about this evening. So according to the report of the UNESCO, in April 2020, it said COVID-19 interrupted learning in class of about 9 in 10 children. And that out of 191 countries, over 1.5 billion people between pre-primary education, and tertiary education. Excuse me. Right. Can you hear me, please?
Yeah, can you, sorry about that. I had to mute the microphone.
All right. So
Yeah,
as I was saying, according to the UNESCO report, so April 2020, we saw 9 out of 10 children out of class. The learning in class was interrupted. So in 191 countries around the world, we had over 1.5 billion students between the ranges of pre-primary school and tertiary education out of school due to COVID. So because it was impossible to project when COVID was going to be over, online teaching and learning had to be introduced, and in some cases, hybrid. In other words, people coming to school on particular days and then running the online versions on other days of the week. So this largely impacted education, and it impacted to the extent that people were not prepared for what was coming in terms of education. People were just guessing as to what steps to take next to make sure that everything was fine. The experience at the Nigerian law school was no different. So the institution itself was closed for about a year. It was closed from about end of March till 2020 till January 2021. So what do we do at the Nigerian law school? We know that it's a vocational training institute for law graduates who are aspiring to become barristers and to have their names enrolled at the Supreme Court in Nigeria. And who is a lawyer? We know that a lawyer is one trained in the theory and practice of law and qualified to offer legal services to persons. And of course, lawyers don't work for free, they work for a fee. In Nigeria, we have a fused system of legal practice where when you qualify, you qualify both as a barrister and a solicitor, unlike in some clients where you qualify either as a barrister or as a solicitor. So who is a barrister? A barrister is the person called to the bar and entitled to practice as an advocate. So he does advocacy, he does litigation, he represents clients in courts, most especially in the US, is who we call the attorney. On the other hand, the job of a solicitor is more conservative. So he normally will step back in office doing legal work, giving advice and support to clients, preparing formal legal documents, and he doesn't formally litigate. He may involve himself in ADR practices, but he doesn't formally litigate. So in Nigeria, the road to becoming a lawyer is quite simple. All you need to do is to obtain your qualifying certificate. You get called to the bar and you have your name enrolled on the list of persons that can practice law in Nigeria, that is at the Supreme Court. So for you to get a qualifying certificate, you must have successfully completed the course at the Nigerian law school, which includes training, in-class training, as well as the externship period, the time you visit the courts and the chambers and learn what is done there. And then you have to pass the exams conducted by the Council of Legal Education. Then you have to put character, and then you must have 3 times. For call to the bar, you must produce that qualifying certificate that was earlier mentioned. You must possess good character, you must pay your prescribed practicing fees, and you must have dined 3 times. So some of these things, they appear to overlap. I've said this thing like twice. So for your qualifying certificate, it's the Council of Legal Education that established the Nigerian law school that gives you your qualifying certificate. Whereas for your call to bar certificate, it is the body of benchers that gives that to you. Once you get your call to bar certificates and your qualifying certificates, then you can go to the Supreme Court and have your name enrolled as persons that can practice as lawyers. So that's the normal trend. When COVID came, we normally have about 18 weeks of class activities. We got to 7 weeks and COVID struck and school had to close. So people went home and online classes were introduced and the Google Classroom tool was used. When the restrictions were lifted, students were allowed to come back. Students were given 5 weeks of intensive coaching, preparing them for the examinations. They sat the examinations, the ones that passed went ahead to be called to the bar and went ahead to enroll. Unfortunately for them, there was nothing like an externship exercise, unfortunately. So they didn't have a chance to learn hands-on what they had been taught during school and see it play out during practice. So this brings me to this discussion of work-based learning. What is work-based learning? Work-based learning is just a practical learning approach. It teaches you the know-how after the know-what. So in other words, you have learned the know-what within the walls of the classroom, then how is it applied is what you learn in practice. So it provides real-life practical work experiences applied to academic and technical skills. So it integrates what you have learned in the university, or in this case, in law school, with what obtains in the workplace. So the benefits of work-based learning include the following: improved set skills, increased understanding, creating deeper impact, and better retention of knowledge. So because what you see being done sticks with you longer than what you have been read. So obviously work-based learning is recommended. So you have different types of work-based learning. You have the clinical experience, which my colleague referred to, where you have the clinical clinics within the law school. You have internships, you have entrepreneurship, you have externships, and so on. What we're concerned with is externship at the Nigerian law school. So what is externship in itself? Externship I have defined as the field placements where students earn academic credit for qualifying legal work under supervision of experienced lawyers. So it enables students to integrate theoretical knowledge of the law with the development of professional skills through practical experience. Who is it supervised by? It's supervised by the Faculty of Law, that is the staff, the teaching staff at the law school, the bench, members, the judges, and the members of the legal profession, the lawyers. So it offers students a unique and invaluable perspective on practice of law and the role of lawyers in the society. So still on externship, law students develop and practice essential lawyering skills, review clients and cases, increase students' opportunities to build relationship with lawyers in practice while applying their legal education to practical service for clients. So before 2009, we used to run what was called the attachment. During attachment, there was no real supervision. All that needed to happen was for faculty members to go to different states and see whether the students were actually present. But now, after 2009, things changed. You don't go and supervise them. You put the judges and the lawyers, you make them the supervisors of what the students are doing. So when they come back and account to the faculty of what they were able to learn during the externship exercise. So the court externship lasts for 6 weeks normally, and the law office externship lasts for 6 weeks as well. So what do they bring back? They bring back a portfolio. What does the portfolio contain? It contains that they actually attended, signs of attendance, activities, observations, practical skills, as well as the ethical values that they didn't do that period. Survey forms, and many of these survey forms attest to the fact that what they actually learned during their externship period correlates to what they were taught in the Nigerian law school, which makes the externship period valuable for them. The class of 2020,
you have 5 minutes
you can see
left,
a missing link. Right, you can see a missing link. So in other words, they had no stint at law practice. Can you say that they were deficient? I will answer that in the positive. Interacting with them for the people that did not pass the bar exams showed that they could not answer common questions, or they had no good understanding of court practices, of things that happened within the courtroom. So how do externships benefit us? It benefits students because they can relate classroom experiences with practice in the real world, applying skills learned to life situations, developing crucial career readiness, ability to watch and interact with professionals while at work. There are other advantages such as networking, dreams, learning obligations towards workplace, and even knowing how to work this in itself. For everything that has a benefit, obviously has a challenge. What are the challenges? Students think that sometimes it's a waste of time, of their reading time. It's into their reading time, the times the examinations, they're saddled with being frame or in one court. Then where they are sent to a place where they're not interested in what that office specializes in, then it becomes a problem, because if I want to specialize in maritime law and I'm sent to an office that practices matrimonial courses, then I may lose interest. Then unpleasant work memories leading to disinterest, engaging in excessive or debasing tasks, such that when the students go on externship, employers use them because they're not paid, and then exposure to unethical conduct. So when you weigh the challenges against the benefits definitely outweigh the challenges. So has a gap been, is there a gap? There's obviously a gap. Does this gap need to be filled? It obviously needs to be filled. So what are the solutions? The solutions that I find, and I would like to hear from other people, are that you defer the externship exercise to a suitable time before the students write their examinations. Before they go ahead to pass and be called lawyers, let them fulfill that gap, or let them fill the gap that was missed in the course of their training. Then there's a mandatory continuing legal education run by the MBA. Let the MBA take on students, even after they were not able to go to law offices or courts, and they have been called to bar. Make them do courses on endpoints to be able to make an externship system where physical training is achievable. So sorry?
You went up earlier, so
the offices be sorry?
The connection went off, so I asked if you were still there.
Okay, I'm there. So what did you hear me up to?
D3 on continuing legal education. Hello. Hello, Dr. Hameed. Hello. Yes, we've lost her. No. She went off. So I guess we can proceed. She's the Joy? No, she's not Joy. She's T-Square. I hope she'll be able to join us. She still has about 2 minutes left. Do you have a question? Huh? Oh, she has a minute left. Okay. Hopefully, maybe she can still join us. Hopefully, she can still join us later. While she's yet to reconnect, maybe I'll use the opportunity to present my paper. Okay. So let me reintroduce myself. I'm Dr. Simon Ajasin, senior lecturer at Adekunle University, Ondo State, Nigeria. We also double as the acting head of the Department of Jurisprudence and International Law. So this afternoon, I'll be speaking on a paper titled Investigating Corruption Through Transactional Justice as a bringing the legal profession and judiciary to an all-time low in Nigeria, the imperatives for regulation. Okay. So I'll start with the introduction, the introductory aspect of the paper. So please let me know when I'm running out of time in 5 minutes to the end. Okay. So it is right that lawyers are expected to promote and foster the cause of justice by maintaining high standards of the legal profession. Also, judges are also to uphold the principle of the impartiality and integrity of the judiciary. So, however, due to corruption as a result of transactional justice, both lawyers and judges have not been able to live up to these expectations expected of them as members of the legal profession. Yeah, as a result of transactional justice, which is the pandemic soiling the temple of justice in the country. it is right also that corruption has eaten deep into every fabric of the Nigerian society, every facet of the Nigerian society. And Nigeria was ranked by by Transparency International as Nigeria scored 24 out of 100, making it the 158th corrupt country out of 180 countries under the Corruption Perception Index of 2021, which was released in January 2022. So having that as a background, this also shows that where there's corruption, definitely there will be a failed state. And Nigeria was recently also attributed to be, was also described as a failed state because why it has the attributes of a failed state, which includes corruption, lack of educational and medical services, and also other attributes are what internal strife, which is the insurgency in the middle, in the northeast part of the country. Now we also have banditry, which is common in the northwest part of the country, as well Zamfara state to be precise as well, and also kidnapping, which is also rampant both in northern and southern part of the country as well. So definitely, it has the attribute. The country has that the attribute of a failed state. And in addition to all that, in 2018, the country overtook India as the poverty capital of the world, with people living less than $1.90 per day. And although India took the position back in 2021. So having that as a background, so I will discuss briefly about the legal profession. The legal profession was inherited from the British as a result of colonial rule. But unlike in Britain, where you have
Sorry, my connection just crashed. No explanation.
Okay. Yeah,
Sorry about that.
Less than a minute. I don't know, but I've started my own presentation because we don't know when you're going to come back on board. So I don't should I continue with mine or okay, let me finish, then you just conclude.
Okay. All right.
Okay. Thank you very much. Okay. So so as I was saying, the country, where was I? Yeah, the country was named as the poverty capital of the world in 2018, but India took this position back in 2021 as well too. So having talked about that, yeah, I'm on the legal profession. Yeah, so just like I said, it was inherited from the British as a result of colonial rule, and unlike Britain where it was imported from, it's a fused system in Nigeria. Once you are called to the bar, you can practice as a barrister and a solicitor. Unlike in England, where you have to practice just as one. Then, despite the nobility of the legal profession, corruption has really eaten deep into it as well too. Just like every other segment, every facet of the society, especially in the administration of justice within the country. So, the legal profession can be said to be synonymous with corruption. We could see a very good example that comes to mind is the case of the then President of the Court of Appeal, Justice Ajasin, and the then Chief Justice of Nigeria, Justice Aloysius Castinalo, on the gubernatorial election petition of Sokoto State back then, and the unwarranted promotion of Ajasin to the Supreme Court by the CJN. So, also, we also can also look at the issue of whereby judges falsify their ages in order to stay longer on the bench. This is also a form of corruption as well too. There was a particular point in time where the NDC had to sanction 2 judges from Yobe, one from Niger, and I think one from Osun State as well too, in respect of falsification of ages. And another one is the recent occurrence between the immediate past Chief Justice of Nigeria, Tanko Mohammed, and his brother justices at the Supreme Court, on the bench of the Supreme Court, whereby the 14 justices wrote an internal memo which was leaked, alleging of corruptions and corrupt practices and financial impropriety, and not taking care of their welfare. And this was also rightly pointed out by Justice Ejemba Eko during his valedictory service in May, where he said he's leaving the bench of the Supreme Court with concerns and everything, and he called for the Auditor General of the Federation and investigating agencies such as the ICPC to look at the financial impropriety and the financial records of the Supreme Court. So these are instances of corruption on the bench in the legal profession. Then when you look at that of the members of the bar, because just like I said, it's legal profession consists of the bar and the bench. Because they remember the case of Kule Kale Ajasin and during the election petition of Osun State then, where we had exparty communications with Justice Thomas Naron of Plateau State, which shared the panel back then, which led to the subsequent dismissal of Justice Thomas Naron and sanctions against Kule Kale Ajasin himself. Then also the current issue of Chief Adekunle, who happens also to be the chairman body of benches of the country, which with the NBA calling for his resignation, which involved a partner in his law firm, the daughter of his son, as well as senior advocate of Nigeria, going on unethical, unhealthy practices to snatch clients of another lawyer, despite the case being resolved out of court over months earlier. So these are issues of corruptions in the legal profession. So having discussed that, so I'll now move to the crux of this topic, which is on transactional justice and judicial corruption in Nigeria. So what do you mean by transactional justice? Yeah, from the economic angle, the commercial perspective, transactional justice is a business transaction. It involves buying and selling. Yeah, in this instance, the judge is the seller, while the litigant as well is the buyer. So it involves lawyers as carriers of corrupt money, of dishonest money, who pay the same to judges, and those judges sell judgment to the highest bidder. So that's transactional justice in a nutshell. That's an aspect of it. I'll be discussing on 3 more aspects of it in the course of the discussion. So now, when in instances like that, yeah, just like I said, the judge is the seller, the client is the buyer. So most times because they don't trust themselves or there's no link between them, the lawyer comes in as a middleman to facilitate transactional justice, which can also be known as cash and carry judgments, which informs whereby judgment is sold to the highest bidder and cases are won not on merit. So having discussed that, so the judiciary has been ravaged with this for some time now, and even between 2018 and 2020, the judiciary was on the Nigerian Corruption Index as the most corrupt institution in the country with a score of 63, which by the survey conducted by the ICPC. So a former chairman of INEC as well, Professor Jega, also made mention of corruption involving transactional justice by members of the bar and members of the bench, especially in election petition cases, whereby money is being offered by lawyers to judges to win election cases. And in such instances, the judges resign thereafter in order to avoid sanctions from the NJC. And in light of this, during the course of my research, I read somewhere where before the present democratic dispensation in the country in 1999, judges were not corrupt, though there were few bad eggs, but there were just few in number. But now, with the advent of democracy and politicians trying to hold on to power at all costs, they started bribing judges and everything. So that's why by the virtue of that, they could not live up to their oaths of office. And they could not live up to their oaths of office. So just in passing, I'll just discuss some instances of transactional justice in the aspect of exchange of money. There was a case of Mr. Godwin Obla, a senior advocate of Nigeria, and the equivalent of the Queen's Counsel in the UK, and Justice Rita Jumobobia of the Federal High Court, whereby he paid money into the account of the company's account of Justice Amuga, where she is a director and so signatory to a private company, which is against the ethics of the judicial officer, and had expected communication with the judge while cases were ongoing. They also have the case of Justice James Abadu, official of the Nigerian the National Industrial Court of Nigeria, who was found wanting of transactional justice as well too, by collection of money from lawyers under the pretext that he was bereaved and his salary was not being paid on time. So, and people even offered him money, included the then legal advisor of the ruling party in Nigeria, the People's Congress, Dr. Odigie-Emmanuel, who made a payment of 500,000 naira to him. We also have the former president of the NBA as well, too, Olusegun, who made an unethical payment of 550,000 naira to him in 3 different tranches of 250, 100, and 200, while his law firm had 32 cases pending before the NICN. Then they also moved this monetary gift by Banire and Usoro are flagrant violations of Rule 34 of the rules of the professional conduct, which is that a lawyer should not be calculated to gain special personal consideration or favor from a judge. Then also another third instance of a judge who was involved in transactional justice was the former CJ of Erugo State, Umezulike, who accepted a donation of 10 million naira from a client. While he had 2 cases pending before him, under the pretext of that the money was supposed to be used for, it was received as a book loan, but he used the money subsequently to purchase treasury bonds. So, yeah, that's been said. There was also the case of Justice Samia, who was the presiding justice of the Court of Appeal, the London Judicial Division, who was involved in transactional justice when he asked the petitioner to, on 3 different occasions in Sokoto, Abia, and Owerri respectively, where he requested for 200 million naira to influence the decision of the panel, of the Court of Appeal panel in an election petition in Owerri, or even losing the case. Then a legal practitioner that was also involved in transactional justice is Joseph Nwabike, who offered money to Justice Unisa to impress judgment in his favor. It was reported that he gave a sum of 750,000 naira to Justice Unisa to while his mother was had kidney issues and had to undergo dialysis. So we also gave money to Abia Fisham of the National Industrial Court and Ungajiwa of the Federal High Court as well too. So, and it was also reported that he gave money to court registrars as well too. So the second aspect of personal justice is where litigants hire the best lawyers, and after hiring the best lawyers, they go behind to hire another lawyer who is not directly involved with the case, but has a connection with the judge, so in order to influence the decision. So while the other lawyers are working with the brief, with settling, drafting and settling the brief in the court of law, the other lawyer goes behind to influence the judgment. So then also the third aspect is where some lawyers are perfected this time, whereby their cases are assigned to a particular judge. So Wobike is guilty of this as well too, because there were instances whereby he used the influence of the court clerk at the federal court called GD, sent messages to him that his cases should be assigned to Justice Unisa and one other judge as well too. And out of 11 occasions, GD was able to deliver 7, and all the rulings were in favor of Wobike. This was revealed during the trial. And the further last aspect of transactional justice is allowing personal, family, and social connection to determine cases. So I'm running out of time. So despite all this, transactional justice will have been eradicated, but the main stumbling block against transactional justice in Nigeria is the issue of technicality in the country. And by this, okay, Justice Enekitobi of Blessed Memory gave a description of that in Odigie against the state, which I won't be going into. Then a very good example where legal technicality came into play is the case of Odigie-Emmanuel that I mentioned earlier. That's why they were raising the preliminary objection at the trial that the judge has no right to, does not have jurisdiction to entertain the suit against him because of constitutional precedent that he has not been investigated and dismissed, disciplined by the NJC. What the judge said, no, she has a right to hear the suit. She has jurisdiction to hear the suit. So he appealed to the Court of Appeal, and while the trial was ongoing, the Court of Appeal, Barrister Adekunle, held no, that the court does not have jurisdiction because being a judicial officer, serving judicial officer, he has not been disciplined by the NJC. Also on the issue of technicality, and this case has been referred to as a precedent in other cases as well, in the case against Agbado Fishing of the NICN, even Sylvester Ngota of the Supreme Court, who was one of the justices of the Supreme Court, whose houses were raided, whose house was raided during the October 19, 2016 raid by the Department of State Services. So when we to his counsel who benefited from technicality, he was convicted by the trial court, and the Court of Appeal also affirmed his conviction and the sentencing. But the Supreme Court, by a panel led by the current Martin CJN now, when quashed the conviction and quashed the sentence and nullified his conviction, saying that the section 973 of which where he was convicted, by which he was convicted, section 973 of the Criminal Law of Lagos State 2011, on which he was convicted, does not define what perversion of justice is. And in the draft judgment by Justice Abubakar Tijani, JSC, he stated that he relied on section 3612 of the Constitution of the Federal Republic of Nigeria 1999 as amended, that nobody shall be prosecuted for a crime that is not known to law. So these are mere technicalities. This shows that the Supreme Court has departed from the previous decisions that were held earlier, especially in the cases of where there's technicality and when legislation involves constitution, that the mere technicality should not be applied, but the court should look at the substantive suit itself, should look at the suit of merit. And these solutions were adopted by Callow, Shaw, GSC, in cases such as the state against Gotham, then engineering electrical contractors of Nigeria against the AG of Kaduna State. And this was subsequently also followed by the Supreme Court in Amici against INEC. Sorry, I think I have like 30 seconds left. Let me just Amici against INEC, and it was also followed also as well too in cases such as the AG Edo State versus AG Federation. So this shows that this is a clear depart from the decisions of the Supreme Court previously. So in line with that, it's following there's imperative for regulation whereby the role that a judge should, when cases borders on corruption, on transactional justice, the role that the judge must first of all be disciplined. It is should be amended, should be removed. Because just like it as the judge could be prosecuted without recourse to the NJC in cases that involve arson, theft, murder, manslaughter, corruption too should come into this category of offenses whereby a judge could be prosecuted without recourse to the NJC or the conditional precedent, and the NJC but first of all investigate and discipline the judicial officer. Also, the period of transactional justice on the bench cannot be disconnected from the type of lawyers that are appointed to the bench. So there's the need, because the bench is as good as its bar. So there's the need for continued legal education, teaching of ethics, and upholding professional conduct by lawyers, so that when they get to the bench, they can work harder. I think I have to stop here now. So I want to go by time. Dr. Hameed. Dr. Hameed.
Yes, I'm here.
Okay. Okay, please conclude with your presentation. So you just have a minute left. So we can go into the questions.
You can take it as concluded. It's fine. You can take it as concluded.
You're making some wonderful recommendations earlier.
Sorry?
So you were making some wonderful recommendations earlier.
Yes, I think I was on the last recommendation, talking about online participation by the law school.
Okay. Because I noticed someone nodding ahead in the audience who aligned herself with your submission.
All right.
Okay.
So the solutions. The solutions, is that where? Hello?
Hear me? Hello?
I can hear you now, yes.
Yeah.
I can hear you now.
You're on the final solution, right? The final recommendation.
Yeah, so I talked about the involvement of the NBA and the continuing legal education. I talked about having them, before they're called to bar, asking them to go and conclude or take the internship exercise. And then that technology-wise, the law school should update itself or update its facilities to be able to get the students to participate online rather than presenting themselves physically, so that it can enable them hit the ground running when they eventually become legal practitioners in Nigeria. That's it. Thank you.
Thank you very much for a wonderful presentation.
My pleasure.
Yeah, you're welcome. Questions and answer segment. So any question?
Morning. Sorry, what time are they in Nigeria? The evening.
Evening, yeah, they are 8 hours ahead.
Good evening, colleagues. Mine is not a question, but I want to comment the presenters. I have so much interest in Dr. Zamin's paper. So when she was making her presentation, all her submissions were in tandem with my own opinion, most especially on the fourth recommendation that the students should be allowed to go back and do the externship before being called to the bar. You know, in the Nigerian law school, one of the requirements to be called to the Nigerian bar is for you to pass the portfolio assessment. And we see it as a prerequisite. And if you do not pass that portfolio assessment, you can't be called to the Nigerian bar. So that said, I wondered that why do we have externship program and they were not allowed to do the externship and they were called to the bar? Is that not a negation of one of our objectives as one of our objectives in the Nigerian law school? Similarly, during that COVID period, I observed most of the students, they are just making mockery of our system, that is the Council of Legal Education. On their WhatsApp page, one of the students posted one time that if you get to court and you are asked to move a motion, how will you move the motion? Somebody posted again and said, I will say, I move, go ahead and move. And the next person said, the judge will simply ask you, when were you called? And the person just busted with laughter and said, I am in COVID state. So they're just making mockery of the system. And even the Nigerian law school did not call them after passing the bar final, and they are allowed to go back and do the externship program. Probably won't be, the system will not be subject of mockery. That's my submission. Thank you.
Thank you very much, Odigie-Emmanuel. Mrs. Odigie-Emmanuel.
Good day, colleagues. I just want to add that in my perspective, sincerely, I totally am one person who appreciates all the recent reviews within the legal education system in Nigeria and how impactful the portfolio assessment exercise is supposed to be, the externship exercise itself, because I remember that when I just joined law school, in the first 2 years, I did an extensive review of the difference between the old curriculum and the new curriculum. And, the portfolio assessment exercise really put into perspective some of those recommendations at that time. But I just want to sincerely say that the problem of students in that set not participating in externship is not the students' problem. I think that it's actually a problem of the loss of Nigeria, because those students were posted before in the course of the pandemic. The pandemic was still raging in several countries, but had not yet been a very, very topical subject in Nigeria. Those students, as soon as the pandemic started and it was no longer possible for the students to be accommodated in their externship posting, there ought to be a review. Now, I do not understand it. At least there were some virtual hearings in Nigeria. What was the justification of students not being posted to courts that were sitting online?
Mr. Odigie, you have less than 30 seconds.
Ms. Odigie, I think all
yes.
of us are on the same page that the legal education in Nigeria needs to be restructured.
Yes.
Need not be blamed.
The students are not to be blamed. Thank you, Jumoke. It was a problem. The CJ should have immediately students are posted to courts, they cannot resume. They should have immediately posted those students to virtual courts. At least there were some, although not very prominent, there were some virtual sittings in Nigeria that will at least show us that they appreciated the purpose of the externship program. My major concern is that the bar and the bench, they are not showing that, especially the bar, they are not showing the appreciation of the externship program, that they understand the purpose. Because if you, there was a student that appeared before my panel who the student throughout the course of externship did not go to the courts with the principal, did not go to the land registry, did not go to, you know, even CAC. So whose fault is that? Is it the students' fault? Should we use that to jeopardize the assessment of the students? That is our own problem in the bar. So I really think that the bar has to become more involved in restructuring its impact, not just critiquing the clinical, the Council of Legal Education and the law school system all the time. They need to sit up. They really need to sit up.
Thank you very much,
Thank
Mrs.
you.
Odigie-Emmanuel. Yeah, but I have a question for
Is
you.
Miss.
Miss, okay, Miss, okay. Oh, Lucia, right? Okay. I have a question for you. In the course of representation, you mentioned the Alien Salt Act during the pandemic. Maybe you're with a law firm and you have to file some cases under the Alien Salt Act of the United States.
Okay, no, can I clarify? That is not my.
Please do in 30 seconds.
Yes.
Because I
What I said is that I was talking of the issue of confidentiality and attorney-client privilege. I just made a reference to a case that I was part of. It was Bowoto and et al. Against Chevron. It was a human rights class action that was brought up in the US court. It's a very, very old case. I was just giving I was just giving an example that to be part of the co-counsel in that case, we had to sign a privilege form, because any person, although I did not have I was not called to buy the US system, I could not appear before the court, but I was going to be privy to a lot of information that was privileged. Do you understand? So I had to be signed on. Thank you.
Okay. Yeah, Dr. Hameed, just in 10 seconds, please.
Yeah, I just wanted to raise a view. Make a statement regarding Ms. Odige's view that it is not the fault of the student. She gave an example of somebody that came before her and did not have any contact with the courts or land registry or whatever. The students have been told that where you get to an office and they're not engaging you, disengage yourself and look for where will engage you. I just want to make that comment. So you may not necessarily.
Thank you very much.
Thank you very much.
It's been wonderful having you guys around.
Thank you.
Thank you for the wonderful papers and all. Yeah. Okay, maybe we'll get back home. Hope to meet you one of these days.
It's our pleasure too. Thanks for sharing the.
You're welcome, and have a wonderful.
Thank you very much. Evening. I appreciate it. All right.
You're welcome. Yeah. Bye.
Good morning.
Good morning.